Well, welcome viewers, Dr. J.W. Ayub. The cost of legislative experimentation. When women entered the courtroom to defend boundaries. What does it say about society, the Australian society, when women find themselves entering court to defend boundaries they believe the law had already recognised? For Kirralie Smith, the courtroom became more than a legal venue. It became the place where competing interpretations of rights were publicly tested, exposing tensions between sex-based protections and gender identity protections. Kirralie Smith's campaign eventually moved beyond public debate. The questions she raised increasingly intersected with legal disputes, institutional decisions, and judicial interpretation. This marked a profound shift. The issue was no longer confined to public opinion. It became a matter of how legislation would be interpreted and applied, with different protected rights coming into conflict. For many women following these developments, the courtroom symbolised something larger. It suggested that boundaries they believed were already established now required legal defence. The controversy was no longer simply about what Parliament intended in 2013. It was about how later institutions interpreted the legislation. Each case added another layer. Each decision influenced future policies. Each interpretation shaped how organisations assessed risk, compliance, and competing legal obligations. Kirralie argued that biological sex remained a foundational legal category for many female-only protections. Those who disagreed argued for broader recognition of gender identity within the framework established by the amended law. The courtroom became the place where these competing legal arguments were tested. Whatever position observers took, the process demonstrated that questions many assumed had been settled were, in fact, continuing to evolve through litigation and institutional practice. For Kirralie, this reinforced a central concern. When legal certainty gives way to ongoing interpretation, ordinary women may feel that rights they regarded as secure have become contingent upon future rulings rather than clearly defined legislative bodies. The debate had travelled a long way from the parliamentary chamber. It had entered the courtroom. And there, every decision carried implications extending far beyond individual parties before the judge. When the meaning of legislation continues to be tested in court, its practical boundaries are still being written. The problem is, this rewriting has come at the expense of biological women.